The Ohio Sovereignty Amendment, Part 2, Limitations on State Sovereignty. Section A, Powers and Authorities Restricted by Ohio Constitution. The State of Ohio shall have no powers or authorities except by express provision in this Constitution, and such provision shall be established solely upon the knowledgeable consent of Ohio citizens at the polls. Ohio government shall not usurp any powers or authorities not specifically granted or authorized by this Constitution, nor shall it operate in any capacity of its own or contrary to the collective interests and benefit of Ohio citizens, such interests and benefits within the scope of the Constitution. This provision enhances that of Part 1, Section A. It expressly prohibits the state from exercising any powers or authorities it has not been granted, and those granted must be stipulated in the Constitution as a result of the people's informed vote at the polls. Further, Ohio government is prohibited from operating for its own purposes. Its sole purpose is for the benefit of the people. Government must always remain a servant to the people and not an instrument of tyranny or despotism. Section B, Supremacy of Federal Constitution. Ohio shall support and comply with the Constitution of the United States of America, 1787, as amended and strictly construed, and federal laws compliant therewith. As a member state of the Union, Ohio government has a duty to support and comply with the federal Constitution. However, Ohio government also has a duty to protect the people of Ohio from the federal government. The conflict of these duties necessitates that Ohio public office holders exercise their due diligence to ensure that the mandates of federal government do not exceed its authorities or cause undue harm to the people in Ohio. Therefore, the state is mandated to adhere to the federal Constitution only as strictly construed within its original intent and federal laws made in compliance with it. Section C, Compacts, Contracts, and Treaties. No public servant, agent, department, office, municipality, corporation, or other person or entity, while acting in any public capacity on behalf of Ohio citizens, shall enter into, or participate in, or benefit from any contracts, compacts, treaties, or other public or private agreements contrary to the provisions, purposes, or intent of this Constitution. One of the biggest problems we have with government today is its operating in a capacity or for purposes outside their established purposes. Even though compacts are allowed by Congress at Article 1, Section 10 of the United States Constitution, we deem such an exercise of powers to be detrimental to the security of the people's fundamental rights and liberties. This provision, therefore, imposes a greater limitation upon Ohio government than that of the U.S. Constitution. To preserve our independence, freedom, and prosperity, we must prohibit those representing our interests from participating in any agreement that violates the intent of the Ohio Constitution. The Ohio Sovereignty Amendment, Part 3, Preservation of Sovereignty. Section A, Establishment, Interpretation, and Enforcement of Laws. Subsection 1, Constitutional Compliancy of Laws. This Constitution is the supreme law for Ohio. No law, rule, regulation, or other governing provision shall be enacted, established, enforced, or otherwise implemented or applied contrary to the provisions, purposes, or intent of this Constitution, or that does not specifically identify the relevant authorizing provisions of this Constitution, or that does not clearly and succinctly identify with particularity its purposes, and upon whom said provision shall operate without ambiguity or open limitations. This Constitution and all laws, rules, regulations, and other governing provisions within Ohio shall be interpreted and applied in favor of the people and against government. We must remember the separation between state and federal jurisdiction. The federal Constitution states that it is the supreme law of the land, and it is, within its own scope of jurisdiction. However, for all matters not relating to interstate or international issues, the state constitution is supreme. For Ohio, there is no higher law pertaining to state matters than our Constitution. It is a well-established principle in American law that any statute, rule, regulation, ordinance, or other governing provision that violates the Constitution is null and void, and it creates an injury upon the people. We as Ohioans expect, no, we demand that our government operate within the narrow limitations we have defined in our Constitution, and therefore all laws and other governing provisions implemented in Ohio must be constitutionally compliant before they can be enacted and enforced against the people. We further believe that to ensure constitutional compliancy, every law and other governing provision must expressly state its constitutional authority and upon whom such laws will operate. Subsection 2. Laws subject to constitutional challenge. The constitutionality of every law, rule, regulation, or other governing provision of Ohio and its political subdivisions shall be subject to direct challenge through the Supreme Court of Ohio. Such challenges shall be granted without cause upon a showing of viable constitutional merit. Ohioans have the right to hold their government in compliance with the Constitution. This includes the right to challenge any law that appears to violate the Constitution. Such challenges would be conducted through the Supreme Court of Ohio. To reduce the number of frivolous challenges, the Supreme Court would establish a process by which to evaluate each challenge on its constitutional merits. If the matter had already been determined, then an answer referencing the facts and law would be issued. For those challenges having legitimate claims, the Supreme Court must hear them and render an appropriate determination. Subsection 3. Limitation on regulatory laws. Regulatory laws may be established and enforced as reasonable and minimally necessary to protect the public's actual health and safety, but only upon production of sufficient supporting evidence that clearly justifies such laws. There are many kinds of law: substantive, procedural, regulatory, emergency, enabling, appropriating, criminal, civil, and so forth. While all of these must be compliant with the Constitution, two, regulatory and emergency, are of particular importance to our individual sovereignty. Regulatory laws in particular are used to limit the free exercise of our rights and liberties. Their purpose is to protect us from the trespasses and abuses of others while exercising their rights and liberties. Over time, these two particular kinds of law have been used to encumber our rights and liberties far beyond what is reasonable. We believe that limitations must be placed on government to ensure that the law is not used to steal our freedoms. Subsection 4. Limitation on emergency laws. Emergency provisions may only be established and enforced under extraordinary circumstances to protect the people in Ohio from a clear and present danger, and they must clearly define both said emergency and upon what reasonably obtainable conditions said emergency will cease. Ohio government shall work diligently to resolve all such emergencies and thereupon repeal the relevant emergency provisions. Emergency laws can be very important in protecting us from danger and other matters of immediate and extraordinary concern. However, they can be used to easily usurp and severely hinder the free exercise of our rights and liberties. The federal government has operated under a perpetual state of emergency since 1933, and as a result has effectively set aside our constitutions. It is time for the United States to declare peace and restore constitutional government. And we must protect ourselves to ensure similarly bad behavior is not perpetrated in Ohio. Subsection 5, Establishment of Official Dictionary. Whereas it is the responsibility of every citizen to know and understand the law as it applies to them, it shall be the combined duty of the General Assembly and the Supreme Court of Ohio to compose and maintain an official dictionary for the clear and precise definition of all significant terms and phrases used in writing and interpreting the laws, rules, regulations, and other governing provisions of Ohio. Said dictionary shall be made readily available to the people through the office of the Ohio Secretary of State. It shall be expressly identified and incorporated into the law by reference. Every member of society is responsible to know the law as it applies to them. Without such knowledge, the people may commit offenses that incur fines and penalties without understanding that their act was illegal. It is only reasonable that if the people have a duty to understand the law, then they must be familiar with the terms and phrases that comprise the law. The proper way of making this available to the people is through an official dictionary. Since it is the duty of the General Assembly and the Supreme Court of Ohio to enact and interpret the law, then the duty to create and maintain an official dictionary of Ohio law should be their combined responsibility. Once an official dictionary is comprised, then the Ohio Secretary of State shall see to it that it be printed and made readily available to the general public. Likewise, this dictionary would automatically become incorporated as the official language of all Ohio laws, rules, regulations, and other governing provisions.